Good afternoon, and thank you for joining us for our Immigration Options After Graduation webinar. I'm Megan Gambino, Assistant Dean for Visa and Immigration Services here at Stony Brook. Before I turn the floor over to Brendan, I wanted to give him a brief introduction. Brendan Bentner is partner in the Immigration Practice Group at Harris Beach Law Firm. Brendan represents employers of all sizes in nearly every industry located throughout New York, the United States, and internationally, and assists with obtaining immigration status and employment authorization for employees in both temporary and permanent visa categories. He has particular expertise in working with colleges and university faculty member and professional staff, as well as professionals in the medical and healthcare industry. Brendan also works extensively with investors, entrepreneurs, and startups in securing investment-based immigration visas. As part of his practice, Brendan also counsels individual clients in immigration processes, including marriage-based and family-based visa processes, asylum applications, and naturalization applications for those seeking U.S. citizenship. So without further ado, I'm going to pass the floor over to Brendan. Thanks so much, Brendan.
Thank you, Megan, and good afternoon, everyone. It's very great to be with you here virtually. I really apologize I wasn't able to make it in person. That was our plan, but unfortunately I got a positive COVID test last week, and so we thought better to do it virtually than have me there presenting with a mask on. So I'm sorry I couldn't be with you all live and in person. I had my ferry ticket booked and everything, so I was ready to come. But I'm glad we were able to switch gears and still do it virtually. And the benefit is I don't have to rush out at the end, so I am happy to stick around at the end of the presentation and answer any questions that there are. So please feel free to write down any questions that come up during the presentation here, and I'm happy to address those as I can at the end of the program. So the goal of today's session is really to give you just some ideas about what your options might be after you graduate. I suspect many of you are currently on either an F1 or a J1 visa. And we will actually talk about some of those categories a little bit and what some of your options are for employment after you graduate in those categories. But also, I want to give you some basic information about the other visa categories that may be available and that you may hear about or want to speak with your employer about, because it's not always easy to find a path in our U.S. immigration system. Once you graduate and finish your F1 status, as we'll talk about, a lot of folks may look to transition to an H-1B. That's a common path we see, but that doesn't always work. And so rather than just having one path in mind or one plan in mind, I want to try to arm you with as much information as possible so that you know the different possibilities that are out there and the different options in case plan A doesn't work, and you can work with your employer or immigration attorney to figure out plan B, C, and D and other options that may exist for you. So essentially how I'll structure the presentation, the first couple slides, I'll go over some very basic general information about our U.S. immigration system and how it works. I'll then talk about some of the temporary or what we call non-immigrant visa options. Those are most of what we call work visas, or the temporary visas that will allow you to start working after you graduate. And then from there at the end, the end part of the presentation, I'll speak about some of the immigrant visa options or green card categories and paths that may exist, because those might be something that are available to some of you either now or at some point in the future. So just at the beginning, and many of you may be familiar with these issues in terms already, but I think it's helpful to just sort of make sure we're all on the same page and make sure you're have these issues clarified before we get into the nuts and bolts of this. But I like to I like to start these presentations by clarifying what some of the basic terminology is within U.S. immigration. So a lot of people use the term visa very freely. I have an H-1B visa, I have an F-1 visa. my visa is about to expire. Really, what a visa is a travel document. So a visa is a document you will get in your passport from a US consulate or embassy overseas. And a visa is what allows you to get on a plane, to travel to the United States and present yourself at a port of entry to be admitted to the US. Once you're in the United States, the visa in your passport does not govern what your actual immigration status is in the US. So if you're trying to determine when does my status in the US expire, or what is my current status in the US, you can't always look to the visa in your passport to determine that. You may, for example, enter on one visa type or in one visa classification, and then while you're here, you might change status to something else. And in that situation, you may have, for example, an F1 visa in your passport, but your actual immigration or visa status in the US is something else, like an H1B or an O1. So you may change status, and then your status in the US doesn't match with the visa in your passport. And that's okay, because again, the visa is just a travel document. It doesn't govern your actual status in the US. Same thing with the validity dates. The visa in your passport may be valid for a certain period of time, but that doesn't dictate how long you can actually stay in the United States. So what does determine your status here? How do you find out what your status is and how long you can stay? That is determined by what's called an I-94. And there's two ways you can be issued an I-94. The first is when you enter the United States. So at a port of entry, when you present your visa to seek admission to the US, US Customs and Border Protection will decide whether or not they're going to admit you to the US, and if so, in what classification or what category, and for how long. And once they admit you, they will enter this information on what's called an I-94. In the past, they used to give you a little white card that they would handwrite your class of admission and the period for which you're admitted. For the last several years, it's all been done online. So you don't get any document typically when you enter the US. They'll admit you, and what you then have to do is go on their website, the CBP website, and retrieve your I-94 by entering your name, your birth date, and your passport information. And it will pull up what's here on the left, your online I-94. So that will show the class of admission and the period for which you've been admitted. I always tell folks in any presentation I give, it is a very good idea to every single time you enter the US, check your I-94 online to make sure that everything looks correct. You'd be surprised at how often CBP will admit someone either in the wrong category or for the wrong period. Or sometimes they'll admit you only up until when your passport expires and not when either your visa expires or your underlying visa petition expires. So the only way you'll know when your lawful status in the US expires is by checking your I-94. So it's a very good idea to every single time you enter the US, the first thing you do when you arrive is check your I-94 online to make sure that looks okay. The other way you can be issued an I-94 is by the US Citizenship and Immigration Services, if you file an application to change or extend your status in the US. So once that's approved, you would get the document that looks like this sample on the right, an approval notice or an I-797 from USCIS, which on that bottom portion, it would be perforated, you could tear that off. That is your new I-94. So this is an example of an H-1B approval notice where someone has been granted either an extension of H-1B status or a change to H-1B status, and they've been issued a new I-94. So in this case, if this person pulled their I-94 online, it would show what their status was when they entered. But if their status has since changed or been extended, that's now reflected in the paper I-94 that they would get from USCIS as part of the approval notice. The online I-94 through CBP on the left does not update when you get a change or extension of status granted from within the United States. So in that situation, the approval notice you'd receive would supersede what is shown online as the I-94 that was issued on your most recent entry. And then just another term to clarify is a green card. Again, a term you'll hear a lot. It's not the same as being a citizen. A green card holder is someone who's a lawful permanent resident of the United States. So a green card holder can remain in the US permanently. They can work in the US, but you can lose your green card or permanent resident status. If, for example, you commit a crime that makes you inadmissible, you could have your permanent resident status revoked that way. Or if, for example, you get a green card, become a permanent resident, and then you don't maintain your resident status in the US by, for example, leaving the United States for several years without coming back. By doing that, you could potentially be deemed to have abandoned your permanent resident status in the US. Whereas a US citizen, neither of those circumstances would result in someone losing US citizenship. A US citizen can be outside the US for any duration of time and not lose citizenship. They can, if they commit crimes as well, they would not lose US citizenship. They would just be subject to criminal penalties in the US. So I mentioned at the start, we kind of have three major buckets that I look at, three major stages to the typical immigration journey in the US. Usually most people will start on some sort of non-immigrant visa or a temporary visa, like an F1 or a J1 or an H1B. And then if they want to remain in the US long-term, usually they'll seek to transition to an immigrant visa or a green card. And then the final step would be seeking US citizenship through the naturalization process if they want to. Generally speaking, to become a US citizen, you have to have been a permanent resident or had a green card for a certain number of years. There's certain ways to expedite that, or for example, if someone's parents are US citizens or someone is born in the United States, they would automatically be a US citizen by birth. But for anyone else who's not already automatically a US citizen, you do have to be a permanent resident for a certain number of years before you become eligible to apply for citizenship. So for the first portion of the presentation, I'm going to focus on what's circled here, the non-immigrant visa categories. How our non-immigrant visa system works is, as you can see, that they're each assigned, well, there's different categories, and non-immigrant visas are specific to the type of activity someone can perform in the US while in a particular non-immigrant visa status or classification. So they're limited usually in terms of time. Non-immigrant visas are not valid forever, so they usually will have a specific time period someone's authorized to be in the US. And they'll have certain requirements for how you become eligible, as well as certain limitations on what you can and cannot do in the United States in that status. So for example, what we call a B1 or a B2 visa is someone who's here as a visitor, either as a business visitor or a tourist. Visitors on a B1 or B2 visa can be admitted to the US for up to 6 months at a time. So that would be the time limitation. There are also very strict limitations on visitors being able to work in the US. So generally speaking, someone in a visitor status is not authorized to work or be employed in the US while in that status. So that would be an example of a limitation on what someone can do, the types of activities they can engage in while in the United States in that status. We have a different visa category for almost every letter of the alphabet. I've listed some of the more common ones here, and you can just get a sense of how specific they are sometimes. Obviously, I mentioned B1s for visitors. Many of you are probably familiar with an F1 visa, which is to study in the United States. H visas are some of our common work visas, but it gets very specific. It goes down to R visas for religious workers specifically. Some of these visa categories or visa types are limited to individuals of certain nationalities. So a TN, for example, is only for Canadian and Mexican citizens. So it gets quite complicated to keep track of all these. and understand what they all mean, what they correspond to, and what the limitations and requirements are for each. So a lot of what I do in my job, working with employers and individuals, is looking at a particular individual's situation. What is their educational and experience, background? Where are they from? What do they want to do in the US? What type of job are they seeking to fill? And based on all those different factors, I work with clients to come up with a recommendation as to which visa category would be the most appropriate or the best option for that particular situation. So we have non-immigrant visas. The next category in the middle, you'll see are immigrant visas or green cards, which I'll talk about a little bit later. And then, as I mentioned, oftentimes the final step will be US citizenship. So I'll begin with very briefly going over the work authorization options for individuals who are currently holding F1 status. And really here, I'll give a high level overview, but your best source of information is going to be your DSO or your international student advisor at Stony Brook. They are really experts on F1 issues and applying for OPT. I know they have plenty of resources to assist you in applying for OPT in terms of workshops and other guidance materials to help you through that process. So as you're approaching the end of your studies and your degree program, or even during your degree, there's some options through either CPT, curricular practical training, or pre-completion OPT that your international student advisor can help you with. But just so you're aware of the primary options in terms of after you graduate, F1 students who earn a degree in the US are eligible in most cases for what's called optional practical training, or OPT, which is generally 1 year of work authorization that you can apply for after you graduate. The general rule is that any work you engage in while in OPT must be related to the degree that you obtained, the field of the degree that you studied or that you earned. So it's generally pretty easy to apply for, but it is limited to 1 year in most cases. So usually you might apply for OPT to initially get out into the workforce, but very quickly after getting that, you'll need to be thinking about what are you going to do after that. For some individuals, they may qualify for an additional 2 years of OPT, so a maximum of 3 years through what's called the STEM extension. So if you earn a degree in a qualifying STEM field, science, technology, engineering, or math, you may be eligible to apply for an additional 2-year extension after that 1 year of initial post-completion OPT. You have to have a degree in a STEM field. As I mentioned, it has to be on this specific list that the government puts out of which degrees qualify. The other main limitation to be aware of is that while you're on a STEM extension, so in years 2 and 3 of your OPT, you can only work for an employer that is enrolled in what's called E-Verify. And E-Verify is a federal government program that employers are able to sign up for, but not required to. And so not all employers participate. So you'd have to check if you're on STEM OPT, you have to make sure the employer you are working for or want to work for is enrolled in and using E-Verify for its new hires. And E-Verify is just a way for them to electronically submit a request to the government to verify that a new hire is in fact authorized to work in the US. So keep that in mind. The STEM extension can be good to get you the additional 2 years, but it is limited to only employers that are participating in E-Verify. So usually after OPT, whether it be the 1 year or the STEM extension, the most common option we see get pursued and the one we get the most questions about is what's called an H-1B visa. H-1B is our most common work visa. It's sort of the most basic work visa we have in our system that's not really specialized or specific to a particular set of circumstances. The general requirements for an H-1B are that the position you seek to hold while in that visa status must be what's called a specialty occupation. And there's a very complicated set of legal terms that are used to define what that is. Really, when it comes down to it, what it means is a job that requires as the normal minimum entry-level requirement a bachelor's degree or higher in a particular field or set of fields. So you couldn't use an H-1B to work as a barista at Starbucks because that's not a job that, according to the Department of Labor, typically requires at least a bachelor's degree. So it does have to be a position that requires this education. And obviously you have to have that required education. So your degree has to be at least a bachelor's degree in a field that's closely related to the job or the occupation you seek to hold. H-1Bs are employer specific. So a particular employer would file this petition for you, the H-1B visa petition. And if and when it gets approved, that petition and that status allows you to work for that specific employer only. So you can't use an H-1B through employer A to just go work for employers B, C, and D. You can work for multiple employers, but because it's employer specific, you would have to have each employer you want to work for file its own H-1B visa petition for you through what's called concurrent employment. So it can be part-time employment, it can be full-time employment. You can work for multiple employers, but if you are, you need each employer to have its own separate H-1B visa petition filed for you. You can obtain H-1B status for up to 3 years at a time, so 3 years in each petition, and a maximum total of 6 years. So for instance, you could get H-1B status approved for 3 years initially, and your employer could then, at the end of those 3 years, file another petition to extend your H-1B status for an additional 3 years for a maximum of 6. Another instance, again, where you want to be looking ahead. Okay, so if you obtain H-1B status, you don't want to wait until year 5.5 of H-1B status and then say, okay, well, what am I going to do next? Because I only have 6 months left of my H-1B before I reach that 6-year limit, and I can't extend it beyond that. So where should we go from here? A lot of times the next step after this will be a green card or permanent residency. But as we'll talk about, that process can take 2 to 3 years, even under the most standard, complication-free process. So you want to be planning ahead. And I would say after you get H-1B status, at the latest, by the time you're ready to file that first extension after your first 3 years, you likely want to be speaking to your employer about the possibility of pursuing a green card or permanent residency to see if that's something they're willing to do and sort of what that process would look like. You don't want to wait too long because you may be shutting out some possible options for you. Now, the big issue with H-1Bs, I mentioned they're our most common work visa, the most sort of flexible, most standard option. The biggest issue and limitation with them is they are limited in number each year. So every year in our system, we only have a total of 85,000 H-1Bs available. I show here we have 65,000 under what we call the normal cap. There's an additional 20,000 H-1B visas available specifically for individuals who have a master's degree or higher from a US college or university. So the 65,000 plus the 20,000 advanced degree exemption is a total of 85,000. 85,000 in a vacuum might sound like a lot, but it is not. It's not nearly enough for the demand that's out there. Last year, just for reference, there were nearly 500,000 submissions in what we call the H-1B lottery for those 85,000 visas. And so the way the government allocates these is every year they hold a random lottery, sometimes called the H-1B cap, where in mid to late March, there's a couple weeks of a window when they will allow employers to submit an online registration or entry in this lottery on behalf of any individual that employer wants to sponsor for an H-1B visa. So an online submission is filed in March, and in early April, the government takes all those submissions and randomly selects 85,000 of them, who can then proceed with filing an H-1B visa petition to try to claim one of those visas. So the numbers are not great. The chances are not great, given, as we said, almost 500,000 submissions for 85,000 visas. So you're not guaranteed to get an H-1B visa. So there's a couple of ways around this, or ways you can sort of mitigate the impacts of this cap. One is, for example, if you are someone who's on OPT and you're eligible for the STEM extension, you may think, well, in year one of OPT, I don't have to worry about the H-1B lottery because I have 3 years of OPT. I have my first year and then the 2 more years that I can get for the STEM extension. That can be a mistake because given these limitations with H-1Bs, you want to give yourself the most chances possible at going through this lottery. And so even if you're someone who may qualify for STEM extension of your OPT, it benefits you to have your employer, if they're willing, go through the H-1B lottery for you in year one. And if you're selected, great, you can transition to H-1B status then. If not, at least you have remaining time on your OPT and could try for the H-1B lottery the following year in year 2. If you don't get it then, you still have a 3rd year of OPT to try again. And the more times you try, the more chances you're giving yourself at being selected. The other issue to keep in mind is there are some employers, some types of employers or categories that are exempt from those H-1B numerical limitations, or the H-1B cap. The primary category of exempt employer would be a college or university. So colleges and universities in the United States can file H-1B petitions for employees in any number at any time of the year. They do not have to go through that online registration or that lottery process. So that's a big benefit of when you're weighing your job opportunities. If you're evaluating a job at a college versus a job in industry, obviously the type of job, the salary, the location, all of that stuff's going to be important. But also important is to keep in mind that the job at the college or university will be a much easier path to an H-1B and a long-term visa status if that's something they're willing to do for you. So again, just some important information for you to know going forward. So colleges and universities are the primary form of exempt employer. Other categories are exempt as well, however. So certain nonprofit or government research organizations or nonprofit entities that are affiliated with or related to a college or university. So a good example here is SUNY Stony Brook, the State University of New York, is exempt as a college or university. The Research Foundation for the State University of New York is a separate entity. It is not SUNY itself, but it is a nonprofit entity that is related to SUNY. They have an affiliation with the State University of New York, and therefore the Research Foundation is typically exempt from the H-1B cap because of that affiliation and their nonprofit status. So it's not every nonprofit entity. It has to be a nonprofit and either a research organization, or has to have an affiliation or a relationship to a college or university. Another potential path you could look into is what's called concurrent employment. So I mentioned before, you can be employed with more than one employer at the same time, as long as each one has its own H-1B petition for you. When it comes to the H-1B cap, if you have, let's say, part-time employment with a college or university on a cap exempt H-1B, because it's a college or university that is the petitioner or the sponsor, you could at the same time work for another employer that is, or that would typically be subject to the H-1B cap or the H-1B lottery. And essentially, by virtue of you being concurrently or simultaneously employed on an H-1B with a cap exempt entity, the college or university, your other H-1B petition automatically becomes exempt from the H-1B lottery and would not have to go through that lottery process. So again, another sometimes creative option to keep in mind if that's something you can manage, is sort of having that dual employment that could make your other employment cap exempt as well. Now, one thing to keep in mind is if, let's say, when you, your first H-1B, you start working for a college or university or some other cap exempt employer. So you don't go through the lottery, you start working with a cap exempt employer on an H-1B. It is permissible to change employers or transfer employers while in H-1B status. So your new employer could file its own H-1B petition for you to authorize you to change employers. If that new employer, however, is an employer that would typically have to go through the cap or the lottery, so it's not a college or university, it's not a nonprofit that's related to a college or university, then you can't just transition to that new employer anytime. They can't just file an H-1B petition for you. Because you have not gone through the lottery yet, your new employer's petition would have to be selected in the lottery in order for you to go through that change or that transition, or that transfer of your H-1B employer. So the H-1B cap is definitely something to be aware of. It really limits the timing of when H-1B petitions can be filed and limits the likelihood or of success of the H-1B if it's a cap subject employer. So certainly something to remember. And because of these limitations of the H-1B, a lot of times we have to look at alternatives. If the H-1B is not successful, we like to evaluate what other possible visa options are out there that could authorize someone to work if they're not selected in the H-1B lottery. So I've listed some of the more common work-based visas here. I'll go through some of them in a little bit more detail in the coming slides. A J-1 visa is not really a work visa per se. It's an exchange visa and a lot of times is used for training, but it can be used for sort of work adjacent positions. So programs or opportunities that are similar to work or employment. For example, a lot of research-based positions may qualify for a J-1 as a research scholar. There's many different categories of J-1s. I mentioned research scholar. J-1s can be done for trainees or interns. So we see J-1s quite a bit in higher education and academia when there's research involved. The J-1 is, you'd work in most cases with the International Student and Scholars Office. They're handled similarly in most cases to F-1 visas in terms of how the paperwork is issued, how the visa is obtained. So a lot of times the same folks will assist with J-1 visas at the institution as would with F-1 visas. One issue to keep in mind with J-1 visas is if you do obtain J-1 visa status or a J-1 visa and enter the US using that, some J-1 visas or programs will subject the individual to what's called a 2-year home residence requirement. And this is really a byproduct of the J-1 being an exchange visa. So the whole idea or purpose behind J-1 visas is they allow someone to come to the US in an exchange program to participate in some sort of training or education or internship to allow the individual to gain some knowledge or skills that they will then, at the end of their program, go back to their home country to share what they have learned. So in some cases, to enforce this, to require people to go back to their home country, a 2-year home residence requirement will apply and attach. And if it does, it makes you legally ineligible for example, an H-1B visa or for a green card, a permanent resident status, unless and until you either go back to your home country for 2 years at the end of your J-1 program, or you obtain a waiver of that requirement. Now, the ways you might become subject, how do I know if my J-1 program is going to make me subject to this 2-year rule? The ways you could become subject, one is if, as part of your J1 program, you receive funding from either the US government or your home country's government. So if there's any government funding involved, typically you will become subject to the 2-year rule on that basis. Another way is through what's called the skills list, where each country around the world can designate particular program codes or categories of programs that they prioritize. And they essentially say, if someone comes to the US in this particular program code on a J1 visa, then they're going to become subject to this 2-year rule and forced to return to the home country for 2 years or obtain a waiver. The last way would be through graduate medical education or training. So if someone attends medical school, either in the US or abroad, and then they seek training through either a residency program or a fellowship on a J1 visa, they will automatically become subject to the 2-year rule that way. Now, for any of you who have a J1 visa, you might see on the visa in your passport or on your DS 2019 form, there may be an annotation somewhere that indicates whether or not you are subject to this 2-year rule. So the visa or the DS 2019 form might say, bearer is subject to 212E, which is the citation to the law of the 2-year rule, or bearer is not subject to 2-year rule. Keep in mind that those annotations on the visa or on the DS 2019 are very, very often wrong. You can't rely on those. If you are on a J1 and considering any options after a J1 instead of just going back to your home country, I highly recommend either speaking with an immigration lawyer who can help give you an informed opinion as to whether you are in fact subject, or you can submit what's called an advisory opinion request to the US Department of State, where you submit your J1 related documents and they will come back and give an opinion as to whether you are in fact subject. But I would say a third of the time that I look at clients' J visas or DS 2019s, they have incorrect annotations on them. And they'll either say someone is subject when they're not, or they will say someone is not subject when they are. So please don't rely on that and say, well, my visa says I'm not subject, so I'm fine to go ahead with transitioning to an H-1B. That is not always the case. So just be careful there. If you are subject, there are some ways you can get a waiver of that requirement. The most common is what's called a no objection waiver, which would be if your home country does not object to you remaining in the US. So you can get a letter from your home country's embassy in the United States saying, essentially, we're fine with this individual remaining in the US at the end of their J1 program. We don't need to require them to come back. The other waiver categories, one is what's called an exceptional hardship. That's only available if you have a US citizen spouse or child who you can show would suffer exceptional hardship if you had to return to your home country to serve out that 2-year rule. A persecution waiver would be if you can show that you are afraid of returning to your home country because you would be persecuted based on certain characteristics. That may be a potential option to get a waiver. And the last is what's called an interested government agency waiver. If there's some federal agency in the US, like the US Department of Energy, where you're doing research that's funded by them and they have an interest in you remaining in the US, a US government agency can sometimes vouch on your behalf to support a request that you get a waiver and not be required to return to your home country. So again, anytime I see a J1, the first thing I do is evaluate whether someone may be subject to this 2-year rule and might need a waiver. Because if they do, it's going to very much limit their options for transitioning, certainly to an H-1B and also to a green card. You can, if you are subject to the 2-year rule, you can still get other visa types. So a common scenario I'll see is someone who's on a J1 doing research in the US, they are subject to the 2-year rule. And after that, they decide to go back to school and get a PhD in their field of expertise. So it's fine to get an F1 visa while you're still subject to the home residence requirement. The main limitations are you cannot get an H visa, H-1B, an L visa, which probably doesn't apply to many of you if they're intra-company transferees, and a green card. Those are the main things you cannot get while still subject to this 2-year rule. So very quickly, before we get into green cards, there are some other visa options that we'll go over. And some of these, as I mentioned at the beginning of the presentation, are limited to individuals of a particular nationality. So we do have in our system some work visas that are created based on treaties of trade and commerce that the US has with other countries. A common one is it's called a TN, as I mentioned, which is created by virtue of the NAFTA treaty, now the USMCA treaty, between the United States, Canada, and Mexico. And that treaty allows citizens of Canada and Mexico who will work in a certain list of professions or occupations to come to the US in what's called a TN visa status to work in the United States. It can be an attractive option if someone is a Canadian or Mexican because it's not limited in number like an H-1B. So if someone would qualify for a TN, oftentimes we will opt for that path versus an H-1B so as to not have to deal with the uncertainty of the H-1B lottery. Similar options exist for individuals who are from Chile and Singapore. It's called an H-1B1. Very similar to the H-1B in that it requires the job to be a specialty occupation. So one that requires at least a bachelor's degree in a particular field, and the individual must have that required education. And another very similar option for individuals from Australia called an E3. The H-1B1 and the E3 essentially are identical to the H-1B in terms of what's required. The TN is slightly different because they don't utilize this general specialty occupation standard or requirement. For a TN, the treaty between the US, Canada, and Mexico has a specific list of occupations. So your job, your proposed job in the US must fit within one of those listed occupations that are in the treaty to qualify for TN status. Another option we encounter quite a bit is what's called an O1, which is for an individual who has extraordinary ability or achievement in his or her field. So depending on your credentials and your work experience and the things you may have done, the research you may have done during your doctoral degree program or otherwise, you may potentially qualify for an O1. The O1 can be for individuals who have extraordinary ability in sciences, education, business, or athletics. That is what's called our O1A classification. There's also an O1B classification for individuals who have extraordinary ability in the arts. So a lot of times we'll do O1Bs for performing artists, musicians, actors, writers, things like that. An O1A for extraordinary ability in sciences or education or business or athletics requires you to show, as the name says, extraordinary ability. So you have to show that you've been recognized within your field as a whole, that people in your field know you, that you've done things that have impacted your field as a whole. You've, in the context of science and research, you've published articles in journals. Those articles have been cited on a routine basis by other people. You've won awards or received significant grant funding for your research. There may be written work about you, so news articles or online articles about you and your work. You've judged the work of others in your field, so conferences or journals reach out to you to provide feedback on manuscripts or abstracts that are submitted. So you do have to show quite a high level of achievement within your field. If you're just starting out and you haven't really done much in your field yet, the O1 is going to be a difficult option. But for individuals who may have a little more experience or may have a lot of accomplishments, the O1 could be a potential option. And sort of one of the more unique or creative options, I would say, if you have the right circumstances and ability and the entrepreneurial drive to make it happen, is what's called an E2 visa for an investor. So you may finish your education and decide, I don't want to work for someone else. I want to start my own business, and I want to own a business and be the manager and hire people to work for me. So if you have the financial ability to make a substantial investment in either starting up a new business or purchasing an existing business in the United States, based on that investment, you may be able to apply for what's called an E2 visa. So the E2 visa would be, again, based on investment for you to direct or manage a business that in most cases you own. E2 visas, like the TN and the H1B and the H1B1 and the E3 I mentioned, E2 visas are also treaty-based, which means they're only available to individuals from certain nationalities. There's a long list, so it's not just Chile, Singapore, Australia, or Canada and Mexico. There's a much longer list of nationalities that would qualify for an E2 visa, but there are some notable exceptions that do not have these qualifying treaties, those being India and China. So if you are an Indian citizen or a Chinese citizen, you would not be eligible to seek an E2 visa based on investment. So transitioning here from our non-immigrant visas into our permanent visa categories or immigrant visas, what we call green cards. As you'll see here, there's two primary methods to obtain a green card in the United States, either through family or through what we call employment-based categories. Now you'll see some of what we call employment-based categories aren't necessarily employment-based, so to speak, because there are some that allow you to actually petition on your own behalf without needing an employer to sponsor you. But these are the two primary methods or categories, what we call family-based or employment-based. So within employment-based, I'll talk about family-based very quickly at the end, but within employment-based, this is generally what the standard process looks like. There's usually three primary stages to a normal employment-based green card process. So again, as I mentioned in the beginning, normally what happens is you'll start on a non-immigrant visa. So a very, very common path we'll see is an international student comes to the US on an F1 visa to study. They obtain their degree, they apply for OPT after they graduate to get that 1 year of work authorization. During that 1 year, they'll start working for an employer in the US and things are going well. They want to stick with that employer. The employer wants to keep them beyond the 1 year. So the employer seeks to transition them to an H1B, a longer term non-immigrant visa status. Once you get an H1B, as we mentioned, it's more long-term than OPT, but it is not permanent. It's limited to those 6 years. So at some point, the employee and the employer may say, you know what, we know the H1B is limited to 6 years. So how can we extend this relationship and make sure this individual, this employee can remain with us permanently and long-term? So that would be the point at which you might discuss a green card process. Now, through a normal employer-sponsored green card process, as I mentioned, there's three primary stages. The first stage in many processes is what's called a perm labor certification with the US Department of Labor. At this stage, the employer has to go through certain steps to demonstrate that it has tested the labor market and it has done certain things, it has advertised for the position to determine whether there are any US workers in the labor pool who satisfy the minimum education and experience requirements for the position they want to use to sponsor a foreign worker for a green card. And the reason for this is because the general rule is an employer cannot sponsor a foreign worker for a green card unless there are no qualified US workers for the job. So this is not required for an H-1B. It's not required for any of those temporary non-immigrant visa categories we talked about. For those, the employer does not have to show it tried to fill the job with a US worker first. They can just directly go to sponsoring a foreign worker they wish to hire. But for a green card, in many instances, an employer does first have to show that they have tested the labor market to determine if there are any minimally qualified US workers. So to get permission from the US Department of Labor to sponsor a foreign worker, the employer completes this PERM labor certification process. I should update this slide here. We said 6 months for the PERM labor certification. Right now, it's probably closer to 12 to 18 months, just with the current processing times we're seeing for the various steps within that stage. But as I mentioned, generally speaking, this stage involves the employer following certain procedures and following certain steps to essentially advertise for the job as if there's an opening. So an employer places certain ads for the job that you as the foreign worker may already be holding, but the employer is placing ads as if there's an opening to test the labor market and see who applies for the job. And if there are any US workers who apply that are interested in the job, who meet the required minimum qualifications. So if an employer goes through that and they determine that there are no minimally qualified US workers who apply, the employer can submit the labor certification application and get that permission from the US Department of Labor to then proceed with sponsoring a foreign worker. So they would then move on to the next stage, which is the immigrant visa petition. In the employment-based context, that's called a Form I-140. The Form I-130 you see here as well would be in the family-based context. So for a family-based case, the I-130 is the first step, the first filing that gets submitted. But for an employment-based case, the employer submits the I-140 visa petition, which essentially is filed with the US Immigration Agency to tell them, we as the employer have received this certification or this permission from the Department of Labor to sponsor a foreign worker. With the I-140 petition, here is now the foreign worker we wish to sponsor for a green card based on a job that's available to them. And the employer would submit that petition along with evidence or documentation that you, as the proposed immigrant or the intending immigrant, you satisfy whatever the minimum education and experience requirements are. So there are no US workers who satisfy these requirements, but this foreign worker does. And here's proof that they have the required education and prior work experience. If that petition gets approved, then that is what establishes the foreign worker's eligibility to then seek an immigrant visa or a green card based on the petition the employer has filed. So if the employee is in the United States, the final stage is typically what's called adjustment of status, or the employee files an application to adjust their status from a temporary non-immigrant to an immigrant or a permanent resident. If the employee is outside the US, they can go through what's called consular processing, where they can obtain an immigrant visa at a US consulate or embassy abroad to then enter the US as a permanent resident. Now, one issue, so going back to this, it looks pretty straightforward. There's 3 stages. You go from one to the next. For individuals of certain nationalities, there can be a long wait in between some of these stages. And the reason for that is, much like with the H-1B, in the immigrant visa context, the number of visas or green cards are limited each year. So there is not an unlimited number. There's only a very specific number available for employment-based cases and a specific number available for family-based cases. When that limit is reached, which it often is for individuals of certain nationalities, because in addition to being limited by category, there's also a limit on how many of those visas can be issued to individuals from one particular country. So each country cannot use more than approximately 7% of the total number of visas available. So when you have countries where individuals from those countries are seeking to immigrate to the US in high numbers and high volume, like India or China, for example, they use up that 7% every year. So what happens is, instead of doing a random lottery like they do for the H-1B, in the green card context, the government creates these waiting lines or backlogs or queues. And so they don't do a random lottery every year, but they'll say, okay, if you're processing as an individual from India through this employment-based category, all the visas have been used up for this year. So you'll now just be placed in line to wait for a visa to become available to you. And how you determine sort of where your place in line is or how long these waits are, you can look at what's called the Visa Bulletin, which is a document that's produced each month by the US Department of State. And it shows the current cutoff dates, or sort of where things currently stand in each particular month for each particular category and individuals from any particular nationality. So the best way to look at this is to just show you an example. This is an excerpt from the current Visa Bulletin. So November 2022's Visa Bulletin that's been published. And this is from one of the employment-based charts that's in the Visa Bulletin. So you'll see on the first column on the left, we have different categories of employment-based green cards, EB1 down to EB5. These really just are different categories of green cards. Like I said, they have different requirements to be eligible. So depending on the job that you're being offered, it may fall into one of these different categories. The common ones would be EB2 and EB3. EB2 would be for jobs that require a master's degree or higher, or a bachelor's degree and at least 5 years of experience. EB3 would be anything less than that. So let's say your employer is sponsoring you for a job that requires a master's degree. So you'd be an EB2. If you are from France, which is not listed in its own separate column here, you would fall in the worldwide column. So if we look at EB2 worldwide, there's the letter C, which means that category is current. There's no backlog. All of those visas have not yet been used up for this year. However, if you look at the next column for China, if you're a Chinese national and your employer is sponsoring you for a green card for a job that requires a master's degree in EB2, we see a date there of June 8th, 2019. And what that means is right now there's a backlog in that category. And as of today, in November of 2022, green cards are only available to individuals who started this green card process prior to June 8th of 2019. So in other words, today, this month in November 2022, individuals who had started the green card process in June of 2019 are just now being able to finish the process and submit the last stage of the green card processing to have the green card issued. So what that means is they've been waiting approximately 3.5 years or so to finish the process. If you look a couple of columns over to India, you'll see the wait is even longer. The cutoff date there is April 1st of 2012, which means that now in November 2022, only individuals who started the green card process prior to April 1st of 2012 are able to finish the process because a green card is available to them. So if you're from one of these countries, it's again good to be aware of these backlogs and know that you may not be able to get your green card immediately due to these retrogressions of these backlogs of green card availability. Now, there are scenarios I mentioned. Let's say someone transitions to an H-1B, and I mentioned the H-1B is limited to 6 years total. There is an exception to that. If someone is going through a green card process with their employer, let's say the employer has started the process, and because they're subject to these backlogs, they can do stage 1 and 2. So basically what would happen is you could do the perm labor certification, you could file the immigrant visa petition, the I-140, and get that approved. Once that's approved, that would lock in your place in line. But if there's a backlog in your category, you would then have to stop there. You couldn't submit the last stage of the green card process yet until a green card becomes available to you based on your place in line. So if you're in that situation and from a country that's subject to these backlogs, that would be one scenario where you are allowed to continue extending H-1B status beyond the normal 6-year limit while you wait to process through these green card backlogs. But you'd have to do both of those things simultaneously. You pursue the green card, you get the I-140 petition approved, but having that petition approved by itself does not give you the ability to stay in the US or to work here. So at the same time, you would have to keep maintaining H-1B status, which means you'd have to maintain your employment with your employer. And every 3 years, they're going to have to keep extending your H-1B until you're able to finish the green card process. So it's one of the major drawbacks we have in our system are these limits on available green cards, especially for individuals from India and China who are subject to these long backlogs. It can take quite a while to fully go through the process to actually get your green card. So perm labor certification, I'll skip that because I talked about that already and sort of what that entails. Now, because some of those categories, the EB2 and EB3, are subject to long waits, a lot of times, particularly from individuals from India and China, we will look at what's called the EB1 category, which if we look back at the visa bulletin chart, EB1 for all countries is current. There's a C. So there's no backlog in EB1. The trade-off to EB1 is it's more difficult to get approved. EB1, sort of like the O1 visa we talked about, typically is for individuals who are extraordinary or outstanding in some way. So you do have to show that you're well known within your field. You've made significant contributions to your field, significant original contributions of major significance, that you've done a lot of research work or other extraordinary contributions to your particular field that have gained you some level of recognition as a leading figure within your field. These categories here are exempt, in addition to sometimes not having that backlog, they're also exempt from that whole perm labor certification stage as a whole. So for these categories listed here, the government has said, because these individuals are extraordinary or outstanding, or their work is in the national interests of the United States, we're not going to require their employer to go through the process of showing whether there are any minimally qualified US workers. In other words, even if there's someone out there who meets the bare minimum requirements for this job, we don't want that to impact an employer's ability or this individual's ability to obtain a green card if they are extraordinary or outstanding in some way. So these categories of green card are exempt from that labor market test. You don't have to go through that process. You go directly to filing the I-140 immigrant visa petition with US Immigration. So I'll speak about some of these a little bit. The individual of extraordinary ability, or EB1A, again, very similar to the O1 in that it's for individuals who have extraordinary ability in sciences, arts, education, business, or athletics. The difference is in the green card context, it's held to a bit higher of a standard than it is for an O1. So you have to show a bit more, even more so that you are extraordinary or well-known within your field nationally or internationally. The positives here to this category can apply to a wide variety of fields, as you see. Anyone who's working in science, art, education, business, or athletics. It also can be filed as what's called a self-petition. So you may be someone who you may not have a specific job offer, or you may be working for an employer who says, we love having you around, but we're just not willing to go through the green card process yet. You know, maybe they have a policy where they make you work for them for a year or 2 years before they would sponsor you for a green card. So this category in extraordinary ability, or EB1A, you can file as a self-petition. which means you can file the petition on your own behalf. Does not require an employer to file it for you. It does not necessarily even require you to have a job offer in the US if you can articulate or show sort of what you'd be doing if the petition got approved, how you would be continuing to remain involved in your area of expertise. So this can be an attractive option, particularly from individuals from India and China who would be subject to those lengthier backlogs in EB2 or EB3. Just for reference, here are the criteria that the government looks at when evaluating these cases. So there's 10 criteria or categories. To be eligible, you have to show that you minimally satisfy at least 3 of these. Now, minimally satisfying at least 3 will get you in the door, but it will not get you approved. To get approved, if you meet the at least 3 criteria, your case would then proceed to the second stage of the analysis by the officer, what they call the final merits analysis, where they'll look at all of your evidence as a whole and determine if you rise to that high level required of someone who's extraordinary or well-known within your field. So you do have to satisfy at least 3 of these bulleted criteria, but just minimally doing so by itself likely would not be a strong case or likely one to get approved. You really have to show a convincing case that, within each of these criteria or as a whole, you are someone who's well-known or extraordinary within your field. There's a similar category in EB1 called EB1B for outstanding professors or researchers. And it's similar because, again, it requires you to show that you've made original contributions of major significance to your field. So you have to show if you're sort of at a level above an ordinary or entry-level person in your field. This category is specifically tailored to higher education and academia. So we do a lot of these for faculty and professors at colleges or universities or similar research-based positions. The criteria are similar, not exactly the same, but the same idea. So in EB1B, there are 6 criteria they will look at. Again, to get in the door and meet the threshold, you have to satisfy at least 2 of those, but same thing. After you meet 2, then they'll do this final merits analysis where they'll look at your case as a whole to decide if you are outstanding. And another category, which is in EB2, so sometimes not a hugely beneficial option to Indian or Chinese nationals because it's subject to this long backlogs. But for individuals of any other nationality, this is one I work on quite a bit with folks because like EB1A for extraordinary ability, it allows you to self-petition. So you could file this petition on your own behalf. You don't need an employer to sponsor you. You don't need a specific job offer. But if you have done some work in your field and can show you have exceptional ability, which is a little bit lower of a standard than extraordinary for EB1A, and you can show that the work you're doing is in some way in the national interests of the United States. So whether you be researching or doing work on public health or economics or the environment or anything really that you can tie back to national interests of the United States. The National Interest Waiver Petition, or NIW, can be a very attractive option because of its flexibility. Like I said, it can be filed as a self-petition, so you could just file this on your own behalf. And the government seems to be recognizing certain occupations and making it a little bit easier for them recently. So I think it was very late last year, early this year, they put out some new policy guidance, which, for example, said if an individual has an advanced degree, a PhD or a doctoral degree in a STEM field, science, technology, engineering, or math, they will consider that alone as a particularly significant factor when determining if someone's work is in the national interest. So it's basically one of many efforts the government is taking to try to continue to attract and retain individuals who have this expertise in STEM. Obviously, if if you follow higher education at all, it's one of the main priorities of the US government to, continue to foster an interest in STEM among students. And by doing this, by giving this sort of deference to individuals who have doctoral degrees in a STEM field and making it a little bit easier for them to immigrate to the US through the national interest waiver category, they feel, that may be one method of keeping people here after they've done their studies so that they can continue to conduct research in STEM fields. So the NIW is one I consult with people a lot and sort of review their credentials to see if there's any potential case to be made, because it's something you can do. You can do it any time. You could do it directly from OPT. I've had a couple of clients who have started this early enough. They've done enough during their PhD program, for example, where they've done research work, they've gotten some government funding, they've, contributed to journals and reviewed manuscripts and done that sort of stuff in their field. And we are able to, while they're still on OPT, file a national interest waiver petition, file their adjustment of status application, and get their green card or work authorization, sometimes before they even finish their OPT. So they don't have to deal with the H-1B lottery at all because they get their green card before their OPT expires. So something to think about if you have the right credentials, if you've been doing these sort of things during your degree program, the national interest waiver can be a quite attractive option. And then the last things I'll speak about in the last couple minutes here before we turn it over to questions are just some other potential ways you may have available to you to get a green card or permanent residency. So I mentioned family-based green cards as the other general category or path other than employment-based. For family-based green cards, typically what it requires is that you have a family member in the United States who's either a US citizen or a permanent resident, a green card holder already, and it has to be of a particular family relationship. So not all relationships can serve as the basis for a family-based green card. So for example, if you have an aunt or uncle who's a US citizen, they cannot sponsor you directly for a green card. That is not a relationship that can be used as the basis. A grandparent could not sponsor you. A cousin could not sponsor you. Generally speaking, it requires you to have either a spouse, a parent who is a US citizen or a permanent resident, or a child if the child is over 21. A brother or sister can. So if you have a brother or sister who's a US citizen, they could, in theory, petition for you. But much like the employment-based categories, some of these categories have long backlogs as well, including the category for brothers and sisters of US citizens, where the current backlog is about 15 or 16 years. So that's one I get questions about quite a bit and have to tell folks it's possible, you can do it if you have a brother or sister who's a US citizen, but it takes quite a while to actually get your green card that way. On the other end of the spectrum, if you get married to a US citizen, there's no backlog in that process, and that's a very quick process. You can sometimes get your green card in 9 months to a year through marriage to a US citizen. And then the last option I'll mention is what's called the diversity visa lottery. So I know I said government doesn't conduct a lottery to allocate green cards, which generally is true. They do set aside a very small number of immigrant visas or green cards each year to allocate via a random lottery called the diversity visa lottery. This is only available to individuals who are from certain countries that don't typically have a large number of their nationals immigrating to the US. So a lot of countries that have people immigrating to the US in large numbers are not eligible for this. But basically, it's a random lottery. There's no cost to participate. There's no harm or downside in doing it. It's very easy to qualify. You just need to have at least a high school education or 2 years of work experience in a certain set of occupations. And it's just an online submission you would file to participate in the lottery. It is limited. There's a specific window during which you have to apply each year, which just closed, I think, on November 8th of this year. But it's typically most of the month of October and early November each year that you can submit a submission in the diversity visa lottery. So you just missed it this year, but keep an eye on that maybe next October if that's something you're interested in participating in. It's a low number, 55,000 visas each year, which is a drop in the bucket really for the demand that's out there. So the chances of getting a visa through this are not very high, but again, there's really no downside in participating if you qualify. I've listed here some links to government websites you can check out for more information. Obviously, as I mentioned, your International Students Office or at Stony Brook VIS office is a tremendous resource for you on student and scholar related issues, F1s and J1s. And obviously for details on your particular circumstances, it's always good, I think, to speak to an immigration attorney who does immigration. There's a lot of attorneys out there who maybe handle a couple immigration cases a year, but their primary practice is real estate or family law or something like that. And I'm not saying they're bad attorneys, but immigration is quite a complex area of law. So, I do often suggest if you are going to speak to an immigration attorney, looking for someone who practices primarily, if not entirely, in immigration law and someone who's able to keep up with the constant changes that we see in this area. Along those lines, my contact information is here. So you're certainly welcome to contact me if you'd like to speak with me about your particular situation and the options that may be available for you, either for temporary visas or green cards or citizenship or family-based cases. We handle a lot of those. So you're certainly welcome to reach out to me on your individual case. And like I said, I'm happy to take any questions that there may be that may have come in, or if folks want to ask questions now, I've got time and I'm happy to provide any additional information.
Great, thank you, Brendan. That was really informative. One question that came in, and I might be able to answer, but please feel free to chime in, is in case if a student has 2 different STEM degrees, does the regulations allow them 2 extra years beyond their 3 years? So based on the regulations, any student who has completed a second STEM degree, that would need to be at a higher level. So you wouldn't be able to tack on another 2 years to your 3 years if you're doing post-completion OPT and then 2 years of STEM. You would have to complete another STEM degree at a higher level to be eligible for a second STEM 24-month STEM extension. As another question submitted is, if possible, can we get an H-1B visa right away and not apply for OPT?
Potentially, yeah, there's no requirement you do OPT first. You could, in theory, if you're able to coordinate it with your employer, and importantly, the employer would likely have to be a CAP exempt employer like a college or university, because let's say you graduate in May, if you're going through a CAP subject employer and through the H-1B lottery, even if, let's say, you get selected in the H-1B lottery in April, that H-1B through the lottery cannot take effect prior to October 1st of that year. So if you're going through a CAP subject employer, you'd have no way to bridge that gap between your graduation in May and the start of the H-1B in October unless you were to go to OPT first. If it's a CAP exempt employer that doesn't have to go through that lottery, you could arrange it so that you graduate in May and then you start working that same month on the H-1B that a college or university may have filed for you if it's approved by then. So it depends. There definitely are circumstances where you could go directly to H-1B from F1 without going to OPT first.
Great, thank you. Another student asked, do you need to secure employment in order to submit the H-1B petition?
Yes, you have to have an employer. You can't, as an individual, you cannot submit a registration in the H-1B lottery. It has to be filed by an employer on your behalf. So typically it does have to be in connection with a specific job opportunity or job offer that employer has made to you, which will serve as the basis of the H-1B petition that would get filed if it's selected in the lottery.
Great, thank you. Brendan, is there a limit to the number of times a student can apply for the H-1B lottery?
Nope. So I've had, just for an example, I've had a client, they're a consulting company in the US, and they have offices overseas as well. So they have an employee who's been working for them in the UK. So not a student situation. She's been working for them overseas in the UK, and they've been wanting to bring her here. And based on her position and her education and the company situation, really the only potential option is an H-1B. And we have been trying, I think now 4 years in the H-1B lottery to get her selected. So in 2018, we submitted an H-1B petition. It did not get selected. 2019, 20, 21, it never has gotten selected in any of those years, which is bad luck. You'd think after 4 tries, someone would eventually get picked, but it's all random. So, just based on the mathematics of it, that is possible. But there's no limit. They don't say you can only submit 1 entry. You can only submit 1 entry per year, but there's no limit on the number of years you can try, assuming your employer is still willing to do that for you.
Great. One student asked, assuming you get the H-1B approval within the first year, do you still need to go through the OPT STEM extension process?
No. So again, let's go back to a hypothetical situation where you have OPT, you would be eligible for the STEM extension. But in year 1 of your OPT, you get selected in the H-1B lottery and then transition to an H-1B status. So at that point, when your H-1B gets selected in the lottery and then the petition approved, you would change to H-1B status. You'd no longer be in F1 status. So you would not file to extend your OPT because you're no longer, you've left your F1 status behind and moved on to H-1B. If, let's say, you don't get selected in year 1, but you do get selected in year 2 of OPT, so the first year of the 2-year STEM extension, same thing. At that point, you would transition to H-1B status and leave your F1 status behind. You would just essentially give up the remaining year of your STEM extension to instead transition to H-1B status.
Great, thank you. One student asked, are most teaching hospitals H-1B cap exempt?
Usually they are, because most times they are nonprofit, and most times, either if it's not a college or university itself, they will have an affiliation with a college or university. So I do a lot of work in healthcare immigration and work for a lot of hospitals that are not themselves a college or university, but they're a nonprofit institution, and they'll have an affiliation in place with a local medical school for residents to do rotations at that hospital in a particular residency program. So because of that affiliation that they have, that ongoing program that they have in conjunction with the medical school, they're able to get an exemption from the H-1B cap that way.
Great. Is the J1 visa category appropriate for a green card?
So it is possible to transition from J1 to green card directly. This raises some potential issues and concerns with what we call immigrant intent. And what that means is many of our non-immigrant visa types and categories, including a J1, require the individual, as a condition of obtaining that visa or entering the US on that visa or maintaining that status, they require the individual to maintain a residence abroad that they do not intend to abandon. And essentially what that means is you don't have the intent to immigrate to the US or remain in the US permanently. So if, for example, let's say you get a J1 visa at a US consulate and you enter the US on that J1 visa, whether you use these words or not, what you're saying to the US immigration agency at the time you enter is, by using this J1 visa, my intent is to come to the US to participate in this J1 program and then to return to my home country at the end of my authorized stay. So if you enter the US on a J1 visa, and then 2 days later, you turn around and file a green card application, that's going to raise some red flags because the government's going to say, well, wait a second, you just entered the US on a J1 visa, which requires you to have non-immigrant intent, requires you to have the intent to not stay in the US permanently. But then 2 days later, you filed a green card application, which means, or which shows that you're trying to stay in the US permanently. So there's some careful considerations you have to keep in mind when transitioning from many temporary visa statuses like J1 to permanent resident or a green card. It can be done, so it is permissible for someone's intent to change. So let's say you enter on a J1 visa, you're here completing your J1 visa program, and years into that program, you decide, you know what, my situation has changed. And now, while at the time I entered, my intent was to go back, now my mind has changed and now I intend to stay in the US permanently. So in that situation, it is permissible to file a green card application from J1 or another temporary visa status and remain in the US. But you have to be careful about some of those things. Most visa categories will fall into that scenario. There are some, specifically the H-1B, which even though it is a temporary non-immigrant visa, it allows for what's called dual intent. So an H-1B visa holder, again, even though it's a temporary non-immigrant visa, legally it is perfectly fine for an H-1B visa holder to have the intent to stay in the US permanently. So there's a lot more flexibility transitioning from H-1B to green card with respect to timing and travel and things like that than there is from some other categories. But there's always occasionally, we'll see articles pop up that people say you cannot go from TN to green card because the TN does not allow for dual intent. Same with an F1 or a J1. And that's not necessarily true. There are ways to do it if the timing works out and if you're careful about these intent issues.
Thank you. Would the national interest waiver be appropriate for someone who's a musician completing a DMA program in the arts field?
Potentially. I always say with the national interest waiver, I never really eliminate anything as a possibility. There's always possibly an argument you can make as to what the national interests are in that. And certainly, there's interest in having qualified and exceptional artists and performing artists in the United States. There's certainly value in the arts. It might be a little bit more unconventional than a purely science-based case or someone who's doing research in medicine or health or something like that. But certainly could be a potentially viable case depending on the individual's credentials and achievements in their field and sort of what their plan is for what they'll be doing in the US and how that could serve national interest. So again, I wouldn't shut that off necessarily and say there's no chance. It's something that definitely could be explored.
Great, thank you. Would a pending green card application have any impact on a student requesting the 24-month STEM extension?
Could you just repeat that? I think you cut out a little right at the beginning of that question.
I apologize. I think my internet cut out.
That's okay.
Would a pending green card application have any impact on a student requesting the 24-month STEM extension?
That's we get a variation of that question a lot. I would say best to speak with an immigration attorney about your particular situation and possibly with your international student advisor to get their thoughts on that as well. Not necessarily, but depending on what your situation is, there's some issues that you'd want to navigate there. So it could be done. I've had clients who have done it, but again, hard to give a general answer on that. That would be, you want to get specific advice before proceeding there.
Great, thank you. Can someone start the F2A green card process immediately after getting married?
Yes, so any marriage-based green card process, there's no requirement that you have been married a particular amount of time before you can actually file the visa petition and start the process. What they will look at in that case is, the main thing they're looking at is it a bona fide legitimate marriage? Meaning, is it a marriage you entered into because you love the person and not solely for the purpose of getting a green card? So what they look at more so than the date you got married is how long the actual relationship has lasted. You could have been dating someone for 10 years and then you finally decide to get married, and then the day after you get married, you file the visa petition. And I don't see any red flag with doing that. On the opposite end, if let's say you just met the person and then you got married to them the next day, and then you waited 6 months and filed the visa petition, even though you've been married 6 months in that case, as opposed to 1 day in the earlier example, the total length of the relationship is going to be what they're looking at. And they're going to want to see evidence that you have the indicators of a legitimate bona fide relationship. You've been living together, you have joint finances, things like that. So it's not necessarily the date of marriage, but more so the whole relationship that they're looking at to ensure it is a legitimate bona fide relationship.
Great, thank you. If someone has an expired visa, will that impact their national interest waiver application?
So I'll go back to my first slide. It depends if you're talking about an expired visa in your passport or you're talking about your expired immigration visa status in the United States. If you just have an expired visa in your passport, but you're still maintaining valid status in the US, then there's no issue. To get a green card, you don't need to show you have a valid visa in your passport, but generally you do need to have valid lawful immigration status, which is unexpired in the United States. There are some exceptions to that, especially in employment-based cases like a national interest waiver. If, let's say, your status did expire in the US, there's a provision that gives you an automatic forgiveness of failing to maintain status for up to 180 days in an employment-based case. So if your status did expire, but you filed a national interest waiver and the adjustment of status prior to being out of status 180 days, you could still be eligible to get your green card that way. But that's an exception to the general rule, which is when filing for a green card, you have to be in the US in a valid status to be eligible for adjustment of status.
Great, thank you. We have a question here, which I can take. It's asking, how does a student apply for authorization for OPT or CPT? So if you're looking to request OPT or CPT authorization, you would submit the respective request in Access VIS. There's an additional question about whether someone who's authorized for OPT can have more than one employer. So the answer is yes, as long as the work done for both employers is directly related to your degree program. We have a question here, Brendan. How does studying on an H-4 visa impact my job and immigration options after graduation?
So an H-4 is a dependent, for those who don't know, it's a dependent of an H-1B holder. So if wife has an H-1B visa, her husband would be eligible to apply for what's called an H-4 visa as her dependent to accompany her to the United States and remain here with her. Same with any children, they could apply for H-4 visas. Someone who's on an H-4 visa as a dependent of an H-1B holder can study, they can attend school in the United States, no problem. They cannot generally work in the US, however. There's very limited exceptions to when an H-4 holder can apply for work authorization in the US, which is typically when the H-1B holder is going through a green card process through their employer. But absent that scenario, someone who's in H-4 status can study. In terms of limiting your options, you'd still be eligible to change to an H-1B yourself. So if, let's say, the H-4 spouse found an employer that wanted to sponsor them for an H-1B, you could do that. You could seek to transition from H-4 to your own H-1B. The main difference on studying on an H-4 as opposed to, let's say, an F-1 is as an H4 holder, you wouldn't be eligible for the work authorization options that are available to F1 students like CPT and OPT. So you'd have to transition from H4 to some other status to get work authorization.
Thank you. This is a question from a J1 exchange visitor. Does the duration on the DS 2019 or the time spent in the US, including the 30-day grace period, count towards determining eligibility for the J1 research scholar? I think this person is asking about the 12, when does the 12-month bar kick in if they're looking to change from, let's say, a J1 intern category to the J research scholar category?
That's a good question. I believe it's from the end date of the J1 program and not the end date of the J1 grace period, but I'm not 100% sure on that. That's something I probably need to look into to verify. But I believe it runs from the end of the program, which would be the date indicated on the DS 2019.
And with the duration of time, so let's just say if he met he was in the US for 12 months, do you know if it would start the day he enters, he's admitted in J1 status, or the start date of his DS 2019?
Again, not totally sure, so don't quote
Okay.
me. I think it would be the start date on the DS 2019 because you're able to enter up to 30 days prior to the start date. So I believe it would be the start date on the DS 2019, but I'm not 100% sure on that.
Great. We could always follow up with you offline on that question. Let's see. May I start a business using OPT and STEM? I can't apply for an E2 because of my nationality.
So OPT, I believe you could, and Meg, you can correct me if you know any different, but I believe on OPT, the initial 1-year OPT, self-employment is permissible.
Correct.
STEM is a little different. STEM, there's more limitations on the types of employment that will qualify, because for STEM OPT, you and your employer have to go through and complete this detailed training plan, which will essentially outline what the training is that you're going to receive, how you're going to be supervised and monitored during your employment while on STEM OPT. And so if you're the owner of a business and there's not going to be anyone supervising you, you may not be able to adequately complete that training plan, which is a required condition of STEM OPT. So I think it could be potentially okay on the initial OPT, but possibly not okay on STEM OPT.
How much more time do you think we have for questions, Brendan?
I can stick around, so if there's any more in there, feel free.
After 4 years of college in the US and 1 year of working, will I be able to apply for citizenship, or do I have to work for 5 years after graduation?
So the 5 years required to be eligible for citizenship must be as a permanent resident. So to be eligible for citizenship, it's not just that you've been in the US for 5 years, but you have to have been a permanent resident or a green card holder for those 5 years. So if you studied in the US on an F1 and then worked for a year on OPT, none of that time would count because you have not been a permanent resident or a green card holder. You'd first have to obtain a green card, permanent resident status, and then that would start the 5-year clock for you to be eligible to apply for citizenship.
Great. If an F1 student has a child in the US while they're studying here, can the parents of that child apply for a green card?
Only once the child turns 21. So if they give birth in the US, that child cannot sponsor the parents for a green card. The child will be a US citizen by virtue of being born in the US, but only adult US citizen children over 21 sponsor a parent for a green card based on that relationship. So again, the child will be a US citizen, but could not sponsor the parents until the child turns 21.
Great. Someone graduating in May of 2023, when should they submit their OPT application? You can apply for post-completion OPT up to 90 days prior to completion of your program, but no later than 60 days after completion of your program. We have an OPT workshop, so if you have any questions, a lot of questions are coming through about OPT and CPT. I would recommend that you attend one of our OPT and CPT workshops scheduled for this semester, or review the recorded sessions that are on our website. Brendan, thank you so much for your time. This was really, really informative. And I will be uploading a link to the recording as well as Brendan's presentation to our website. I'll also email those links out to anyone who registered for this event. So if you weren't able to stay for the whole time, you'll be able to look back for future reference. Again, thank you, Brendan. This was really informative. I appreciate it.
No problem. Thanks for having me again, and great to speak with you all. And like I said, feel free to reach out if there are questions. Happy to help.
Great. Fantastic. Thanks so much. Have a good one.
Take care. You too.
Bye.
Bye.